This week's question of the week is as follows. I co-signed a note with my girlfriend while we were still living together, and apparently she quit paying the bank and now they're coming after me. What do I do? If you have signed a note as a co-signer with a former girlfriend or anyone else for that matter, you have basically executed or signed a contract, and you're bound by the terms of that contract. Oftentimes people are convinced to sign a promissory note as a co-signer for whatever reason, and they think that they will get away with just signing the note and never hearing about this loan ever again. They simply sign as a co-signer and forget about things. Unfortunately, there's no law that requires the bank or a lender to notify you when the girlfriend or whoever signed the note with you forgets to make the payments or refuses to make the payments. It's very possible that if you co-sign a note, the bank might allow the primary maker of the note, in this case the girlfriend, to go for several months, if not several years, without making a payment before they come to you and ask you to make payment under the note. And at that point the note is very far behind. It's also possible that under the circumstances that the loan could be in default to a point where the lender has called the entire note and they want the full balance from you. And again, you're faced with this situation before you ever know that the girlfriend or whomever ever missed a payment. If you're a co-signer and you've been called upon by the bank to make payment under a note, you should aggressively try to make arrangements with the bank to negotiate payment terms on the balance owed under the note. Hopefully payment terms that are more favorable than the terms that exist under the note, especially if the note is totally in default and they've called the whole note. You need to work with the lender to make sure that your right to go after the primary maker on that note is not extinguished by whatever payments that you make or negotiations that you arrive at with the bank. Specifically, once you work out a payment plan with the bank to pay the debt, assuming they're working with you, then you need to make arrangements to buy the original promissory note and execute a separate promissory note that sets forth the terms that you've agreed upon with the bank. Once you've made the appropriate arrangements with the lender to preserve your rights against the girlfriend or the original maker of the note, you could then bring a claim against that person for the full balance owed under the note to the bank. If you're unable to work anything out with the bank or the lender to make payments on a basis that you can afford or handle, you have options inside and outside of bankruptcy to deal with the bank or the lender. Outside of bankruptcy, you can claim various exemptions under Tennessee law. Specifically, Tennessee Code Annotated, that's the code book for our state. It contains all the laws passed by the legislature. Tennessee Code Annotated Section 26-2-104 through 26-2-111, as well as 26-2-301 and 305, provide the most common exemptions that people claim under Tennessee law. These code sections protect your clothing, they protect 100% of all your retirement funds, and they protect a limited amount of your wages, $10,000 worth of personal property, and anywhere from $5,000 to $50,000 of equity in your home. You can use these exemption statutes to leverage with your creditor and work out a payment plan. Also, under certain circumstances, you can use these statutes within the court system and get a court order from a judge forcing the creditor to accept certain terms of payments due to these exemption statutes. Of course, you also have certain rights under the bankruptcy code. Most consumers seek protection under Chapter 7 or Chapter 13 of the Bankruptcy Code. Both forms of bankruptcy, both Chapter 7 and Chapter 13, impose an automatic injunction upon the filing of a bankruptcy petition that stops your creditors from pursuing collection efforts against you while your case is pending. Both forms of bankruptcy can wipe out debts in some fashion, assuming that you're qualified to file either a Chapter 7 bankruptcy or a Chapter 13 bankruptcy. If you've been sued or the bank is calling you about a debt that you owe them as a result of your co-signing a note, call my office today. We will meet with you. The first meeting is free, and there will be no pressure brought to bear on you to file bankruptcy or take any specific action. We want to come up with a game plan that's acceptable to you and is going to be in your best interest. We'll explore your options with you, and with over 26 years of experience helping people settle their debts and filing consumer bankruptcy petitions, I'm sure that we'll come up with an option that's right for you, and most of all, we'll be able to help you get your life back.
Get your life back. Call the law offices of T. Verner Smith, 423-1888, 423-1888.